Imagine losing your job, not for what you said, but for a single click of Facebook like. This isn't a hypothetical scenario. It's exactly what happened to Daniel Ray Carter Jr., a sheriff's deputy in Virginia. Carter was fired after simply clicking the like button on the Facebook page of his boss's political opponent during a heated election. His employer, Sheriff B.J. Roberts, saw this as an act of insubordination and a public endorsement of an opponent. It raised a critical question. Is a Facebook like protected free speech under the First Amendment, or is it merely an action an employer can penalize? The stakes for Carter were enormous. His career, his livelihood, and potentially his reputation all hinged on this digital interaction. This case would ultimately force the U.S. legal system to grapple with the very nature of online expression and its implications for employment, especially in the public sector. But the court's initial reaction wasn't what most people expected. Feeling unjustly targeted, Daniel Carter didn't just accept his termination. He sued Sheriff Roberts in federal court. Carter argued that his Facebook like was a form of protected speech, a symbolic expression of support for a political candidate, similar to putting a yard sign in his front yard or wearing a campaign button. He believed his First Amendment rights had been violated. The lawsuit sought not only reinstatement to his position, but also damages for lost wages and emotional distress. This wasn't a small claims case. It was a constitutional challenge that could set a precedent for millions of public employees across the United States. If a like wasn't protected, where would the line be drawn for other online activities? The defense, naturally, argued that as an employer, the sheriff had a right to maintain discipline and loyalty within his department, particularly during an election. The court had to decide if a like truly carried the weight of speech. When the case first went before the U.S. District Court for the Eastern District of Virginia, the ruling was a huge blow to Carter. The district court sided with Sheriff Roberts, concluding that a Facebook like did not constitute protected speech under the First Amendment. Their reasoning was surprisingly straightforward and to many quite narrow. They argued that merely clicking like was not substantial enough to be considered a statement or expression in the traditional sense. It wasn't like writing a post, sharing a detailed article, or even commenting. It was, in their view, simply an acknowledgement, a passive gesture devoid of enough content to warrant constitutional protection. This interpretation meant that employers, especially public sector ones, could potentially discipline or fire employees for similar online interactions without fear of violating their constitutional rights. This initial decision sent shockwaves through the online freedom community, but Carter was far from giving up. Undeterred by the initial defeat, Carter appealed the district court's decision to the Fourth Circuit Court of Appeals. This was his chance to convince a higher court that the lower court had fundamentally misunderstood the nature of online communication and the scope of the First Amendment in the digital age. His legal team argued vehemently that a like on Facebook, in today's interconnected world, absolutely conveys a message. It signals approval, support, or endorsement, and when directed at a political campaign, it is undeniably a form of political speech. They pointed out the absurdity of protecting a written comment, but not a button click that achieves the same communicative purpose. The appeals court now had to grapple with this modern dilemma. How do established constitutional principles apply to new technologies and behaviors that didn't exist when those principles were first established? The outcome of this appeal would truly define the legal status of digital interactions for years to come. What would they decide? At the heart of Carter's appeal was a fundamental question. What is speech in the 21st century? Is it limited to spoken words, written text, or traditional forms of protest? Or does it extend to digital gestures, symbols, and interactions that convey meaning to a broad audience? The First Amendment protects freedom of speech, but courts have always had to interpret what constitutes speech in various contexts. For example, burning a flag is considered symbolic speech, as is wearing an armband to protest a war. Carter's lawyers argue that a Facebook like is no different. It's a deliberate act, intended to communicate a message of support to a specific audience and dash. the candidate's followers, and anyone viewing their page. The challenge for the court was to avoid a narrow, outdated definition of speech that would render constitutional protections meaningless in the digital realm. This wasn't just about Carter. It was about defining the boundaries of online expression for everyone. In a landmark decision in 2013, the Fourth Circuit Court of Appeals reversed the district court's ruling. They declared that a Facebook like is indeed protected speech under the First Amendment. This was the critical turning point in Daniel Carter's case, and a massive win for digital free speech. The appeals court reasoned that liking a Facebook page is the internet equivalent of displaying a political sign in one's yard, which is a traditional form of protected speech. They stated that liking a candidate's page communicates a message of approval and support, and thus possesses enough communicative content to be treated as speech. This ruling immediately set a precedent, affirming that online expressions, even simple clicks, are not beyond the reach of constitutional protection. This decision fundamentally shifted how courts must view digital interactions, recognizing their power to convey meaning and influence public discourse. But this protection isn't absolute, especially for public employees. While the Fourth Circuit affirmed that a Facebook like is protected speech, the story doesn't end there for public employees. The First Amendment protections for government workers are not as broad as they are for private citizens. Courts apply a balancing test, weighing the employee's right to free speech against the government employer's interest in promoting efficiency of public services. This is known as the Pickering-Connick test. If the employee's speech is on a matter of public concern and the employee's interest in expressing themselves outweighs the employer's interest in efficiency, then the speech is protected. In Carter's case, his was clearly a matter of public concern and a political election. The court determined that the sheriff's claim of disruption was not strong enough to outweigh Carter's First Amendment rights. This distinction is crucial. Private sector employees generally have fewer free speech protections against their employers, making this ruling particularly significant for government workers. Here's what happens if you get this wrong. Imagine a public school teacher in a small town who posts a lengthy, highly critical screed on Facebook about the school board's new curriculum, accusing them of corruption and incompetence, complete with specific, unverified accusations. While her post is certainly speech and on a matter of public concern, the school district might argue that her specific, inflammatory, and potentially false statements directly disrupt the school environment, undermine parental trust, and interfere with her ability to perform her job effectively. If the court finds the district's interest in maintaining order and efficiency outweighs the teacher's right to post, she could still be legally terminated. The key difference from Carter's case is the intensity and direct impact of the speech. A simple is far less disruptive than a detailed, accusatory post, illustrating the delicate balance courts must strike. It's not a blanket free pass for all online expression. A common myth is that if your social media profiles are set to private, your employer can't use what you post against you. This is largely false. While privacy settings might deter casual viewing, they don't provide ironclad legal protection from employer scrutiny, especially if your posts are discovered through other means, e.g., a friend takes a screenshot and shares it, or you inadvertently accept a supervisor's friend request. Furthermore, many employment contracts include clauses about social media conduct, regardless of privacy settings. The legal question isn't usually how the employer found the content, but whether the content itself provides a legitimate, non-discriminatory reason for disciplinary action. For public employees, the First Amendment offers some protection, but even then, content that significantly disrupts the workplace can still lead to termination. Don't assume privacy settings are a magic shield. They offer practical, not legal, immunity. Always consider the potential impact of your words, visible or not. So, what concrete steps can you take to protect yourself? First, understand your employer's social media policy. Many companies have clear guidelines, and violating them, even if the content isn't illegal, can be ground for termination. Second, Assume anything you post online, regardless of privacy settings, could become public. The internet has a long memory. Third, be particularly cautious about discussing your workplace, colleagues, or clients online. If you're a public employee, understand the Pickering-Connick balancing test. Is your speech on a matter of public concern, and does your interest outweigh your employer's? Finally, if you feel your First Amendment rights have been violated as a public employee, consult with an employment lawyer specializing in constitutional law. They can help you understand your specific situation and whether you have a viable case. Proactive caution is your best defense in the complex landscape of online expression and employment law. After the Fourth Circuit's ruling, the case Bland versus Roberts, later renamed Carter versus Roberts due to a procedural change, was sent back to the district court for further proceedings consistent with the appeals court's finding that a like is protected speech. This meant Sheriff Roberts could no longer argue that Carter's like wasn't speech. He now had to prove that his interest in maintaining efficiency and discipline in the sheriff's office outweighed Carter's First Amendment rights. The case was ultimately settled out of court, avoiding a full trial on damages and specific reinstatement. While the exact settlement terms are confidential, Carter achieved a significant victory by establishing a crucial legal precedent. He fought for his rights and, in doing so, helped define the boundaries of online free speech for countless Americans. This case underscored how quickly legal interpretations must evolve to keep pace with technology and the power of individuals to challenge perceived injustices. But what's the ultimate takeaway for you? The core takeaway from Daniel Carter's case is profound. Your digital actions, even as simple like can carry legal weight and are increasingly recognized as forms of expression. For public employees, the First Amendment does offer protection for online speech on matters of public concern, but it's not absolute. Your employer's interest in a functional workplace is also a valid consideration, and courts will balance these competing interests. For private employees, protections are significantly weaker, often relying on state laws or specific contract terms rather than the First Amendment. This case forces us to be more mindful of our online presence, reminding us that the line between personal opinion and professional conduct can blur instantaneously in the digital world. It's a powerful reminder that our online interactions are not just fleeting moments. They are often permanent records with real-world consequences, shaping legal precedent and impacting our lives. So what's next? Daniel Carter's fight proved that a Facebook like can indeed be protected speech. It was a landmark decision that shaped how we view online expression. The biggest lesson is that while your online actions have consequences, the law is catching up to protect digital rights. If you found this dive into digital free speech fascinating, you might be wondering about another contentious area. What happens when an employee records their boss without consent? Is that protected or a privacy violation? We break down a shocking case where a secret recording led to a huge legal battle. Watch that one next to understand your rights and risks in the workplace. And don't forget to subscribe for more true U.S. legal cases told simply.